Rambam, Maimonides' teachings were in the 14th and final book of Mishnah Torah, dealing with courts and judges. And we are now in the laws of witnesses, right, to a litigation. Chapter 17. When many men of great wisdom and fear of God testify to a person and tell him that they saw so-and-so commit a particular transgression, or borrow money from a colleague, although the listeners believe the matter in his heart, as if he saw it actually transpire, he may not deliver testimony unless he actually sees the matter or the borrower acknowledges the debt verbally to him, saying, "Be a witness to me that so-and-so lent me a mana." So, we're talking about great sages. And if you were to hear, from a great Torah sage that told you that, my friend Ruvain, he borrowed, $100, $1,000, whatever it is, from so-and-so. So for you, it'd be like, oh, it's truth because he wouldn't lie. He's not capable of lying, right? But that's what we're talking about, great men of wisdom, great people. We're not talking otherwise. And therefore, for you, it's like as if you saw the incident. No, it isn't. You can't be a witness based on that. Even from great people, it's still considered, if you will, hearsay, right? So, right. And this concept is derived from the verse in Vayikra, and should he witness, see, or know of the matter? There is no testimony that can be established through sight or knowledge alone, except testimony involving financial matters. Can be established through sight alone, except financial matters is different. One second. Yeah. So you need to have the sight of what happened or the knowledge of it personally. That's the point. Okay. Whenever a person delivers testimony on the basis of statements of others, he is a false witness and transgresses the negative commandment. Do not bear false witness against your neighbor. So you're not only allowed to do it, but you transgress. Therefore, we issue a warning also to witnesses who testify regarding financial matters. How do we warn them? We issue this warning in the presence of all onlookers, telling them the severity of bearing false testimony and the shame suffered by those who deliver such testimony in this world and in the world to come. Afterwards, we order all other people to go outside and leave the witness of the greatest stature inside. We say to him, tell us on basis of what you know that this person owes money to that person. If he says, he told me that a borrower said that I owe him money, or says so-and-so told me that he owed him money, his statements are of no consequence, right? He must say, in our presence, the defendant admitted to the plaintiff that he owes him money, right? He has to admit to it. After we bring the second witness and check his testimony in this matter. If the testimony corroborates each other's, the judge is deliberate over the matter and conclude the judgment. Right? If they don't cooperate, so then they're not appropriate judges, witnesses, and there's no claim to the plaintiff. Following rules apply if a person hid witnesses against his colleague, and that colleague acknowledged his obligation to him in private. The witnesses saw and heard him tell him, "Certainly I owe you this and this amount, but I'm afraid you will call me to judgment tomorrow." This is not a valid testimony unless he makes the acknowledgement in the presence of witnesses. So if they hide, they can't testify, right? Because it has to be done in their presence. Whether a person acknowledged a debt to a colleague, making the admission in a sincere manner that he owes him such and such an amount, he told the witnesses, "You are my witnesses," or he told them, "Serve as witnesses for me." They are valid witnesses, right? Because he said, "Be my witness for this." This applies whether the statement is made by the borrower or whether it was made by the lender and the borrower remains silent as if he's accepting his words. So either the borrower or the lender said it, right? I mean, if the lender says, "No, don't be my witness to this," then he's not accepting, right? There has to be an acceptance of the witness. Needless to say, it applies Okay, needless to say, it applies if he affirmed the appointment of the witnesses with an act of contract, telling them, "Compose a legal document stating that I owe so-and-so this and this amount," or the like. His statement is considered as an admission, and the witnesses may testify on that basis, right? We tell, make a contract. When a teacher tells a student, number 5, "You know that if they would give me all the money in the world, I would not lie. So-and-so owes me a mana. I have one witness against him. Please join him. If he joins him, he is a false witness," right? Because he's only going by hearsay. I would never lie. No, you'd be a false witness by doing that. Number 6, if he tells him, "Come and stand together with me," with the witness, you do not have to testify, but the borrower will become frightened and panic, thinking that you're two witnesses, and he will admit the debt on his own volition. The student is forbidden to stand and make it appear that he is a witness, that he is a witness ever though he does not deliver testimony, right? As if he's going to witness when he's not going to, right? With regard to the similar manner, it says, "Keep distant from words of falsehood." Right? There's a falsehood in that, so therefore don't do it. A person who hires false witnesses to testify against a colleague is not liable according to the court of law, but does have a moral and spiritual obligation, because the witnesses have the obligation because they were hired, right? They're doing the act. The one who hired them isn't doing the act. So he doesn't have a legal obligation, but it's a moral and spiritual obligation. Similarly, right? Because whatever, if he took, because of that, the defendant lost the case. Similarly, one witness who refrains from testifying is not liable according to the court of law, but does have a moral and spiritual obligation. In other words, testimony, that true testimony, that you could be a witness for somebody, right, about whatever the case is, whether it's for the defendant or for the plaintiff, you have a moral obligation. You're not, by court, it's not going to do anything to you, but you do have that obligation. All right, got to finish a chapter. Oh, that's nice.
Thank you, Rabbi.
God bless you all.
Have a blessed day.